Hi, I'm Mike Steger. I'm a copyright and trademark attorney. And a few weeks ago, I talked about filling out a copyright application to get a copyright registration and doing it yourself. And I talked about how it is relatively easy for many people, many business owners to fill out their copyright applications. But I did say there were a couple instances where those applications can be tricky, some things that could trick you up. And today I'm going to talk about a couple of things to watch out for. One thing that you have to submit with your copyright application is what's called a deposit copy, and that is a copy of the copyrighted work that you're looking to protect. And one area where this gets tricky is computer software. So you've got some computer software you developed, you want to get a copyright application for it. Whatever is submitted as the deposit copy is submitted to the Library of Congress, and it's open for anyone to get a copy of as long as they pay the copying fees and the search fees to the Copyright Office. So if you've got competitive software, you don't really want your competitors being able to go in and pull the software out, see all the code, and then they're not going to copy it directly, but they're going to figure out how they can work around it. So with software, you can submit what's called a redacted copy, where you submit, a number of lines at the beginning of the program, a number of lines at the end, and then a note that everything in the middle was redacted for trade secret purposes. But that's one area where people get tripped up on. Another area, and I've mentioned this before, I represent a lot of photographers who are looking to protect their photographs. And if you're going to register each photograph individually, it's going to get really expensive. But what you can do is register a collection of photographs. The collection has to be either all published or unpublished photographs. You cannot mix them up. You can register up to 750 photographs together in one collection. They have to be all first published or created in the same year. They all have to have the same author, which in most cases is just going to mean it's the same photographer who took them all. And they have to have the same copyright claimant, which means the owner of the copyright has to be the same. There are some things in there to trick you up. If you mix published and unpublished photos, it could, depending on what the Supreme Court says in the next year, that could invalidate the registration. These are some of the areas where there are some nuance to your copyright application. I'm Mike Steger. I'm a copyright and trademark attorney. If you have any questions with your copyright application or any other copyright or trademark issues, please give me a call.